So to celebrate World Intellectual Property Day, so this day is celebrated as a World Intellectual Property Day, and the meaning of intellectual property is anything that is invented by someone. Anything that is invented by someone, it can be a symbol, it can be a logo, it can be any invention, or it could be anything, a part of any creative mind out there. So it needs a certain trademark to it in order to maintain its copyright or to maintain its ownership. So intellectual property deals with that. So anything that is made by, developed by someone, in order to maintain the proper ownership of that particular creation, it needs to be certified so that the person can get a recognition or can earn any monetary benefit from it. So Ms. Jyoti Mahanta will be giving a description about this particular intellectual property part. So to celebrate World Intellectual Property, I would like to invite Ms. Jyoti Mahanta to elaborate on this particular day. Ma'am, over to you.
Good morning, everyone. I think I am audible. So today is 26th April, and this date is celebrated as World Intellectual Property Day to raise awareness among the people about the IPR. IPR means Intellectual Property Rights. IPR is basically a protection of any new innovation or creativity. If you have patented or copyright for your innovation or creativity, then no one can steal your idea. If anyone do so, then you can take legal action against them for breaching. So, World Intellectual Property Day is an annual event celebrated on April 26th to raise awareness about the importance of intellectual property rights and the role they play in promoting innovation and creativity. The event was established by the World Intellectual Property Organization, shortly WIPO, in 2000 and is celebrated in countries all around the world. Intellectual property is a term referring to a number of distinct types of creations of the mind which property rights are recognized and the corresponding fields of law. Under the intellectual property rights law, owners are granted certain exclusive rights to a variety of intangible assets such as musical, literary, and artistic works, discoveries, and inventions, and words, phrases, symbols, and design. Intellectual property rights are legal rights governing the use of creation of the human mind. The recognition and protection of these rights is of recent origin. Patents, design, trademarks are considered as industrial property. As per International Convention for the Protection of Industrial Property, the protection of industrial property has its object patents, utility models, industrial designs, trademarks, service marks, trade names, indications of source or application or origin, and the representation of unfair competition when copyrights, geographical indicators, layout, designs, and confidential information were included through industrial property, they all become intellectual property. So there are three types of mainly there are three types of intellectual property rights. Number one is copyright. Number two is trademark. Number two is patent. Number three is trademark. So what is copyright? Copyright is a type of intellectual property that protects original works of authorship as soon as author fixes the work in a tangible form of expression. In copyright law, there are a lot of different types of works, including paintings, photographs, illustration, musical compositions, sound recordings, computer programs, books, poems, blog posts, movies, architectural works, plays, and so much more. And what is patent? A patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. So many people have doubt on copyright and patents. So these are not same. So there is a difference between copyright and patents. So a copyright protects an original work in the tangible fixed form in which it has been set down and not the idea behind the work, whereas the patent protects the creation of inventive concept as well as its reduction to practice. In order for a work to be copyrighted, it must be original and fixed in a tangible medium of statement, and in order for an invention to be patented, it must be novel, non-obvious, and useful. Copyright lasts for the life of the author plus 60 years, while patent lasts for 20 years from the date of application. For a copyright to be infringed, the work itself must have actually been copied, distributed, performed, or displayed, whereas a patent confers a statutory monopoly that prevents independent developer of patented invention from using or selling his creation. Accusation is complex and costly. Like if you create any software, then you have to make patent the software. But for the code or language you have used to make the software, you have to copyright that. Okay, that is the difference between copyright and patents. So next one is trademark. What is trademark? A trademark means a mark capable of being represented graphically and may include a word name, a symbol, device, numeral letters, signature, label, ticket, brand, slogans, pictures, characters, sounds, smell, shape, logo, graphic designs, three-dimensional form, moving image, product or taking features, etc. A trademark is a distinctive sign which identifies certain goods or services those produced or provided by a specific person or enterprise. A trademark is a recognizable sign, design, or expression which identifies products or services of a particular source from those of others. The trademark owner can be an individual, business organization, or any legal entity. A trademark may be located on a package, a label, a voucher, or on the product itself. A trademark is a visual symbol or sign in the form of a word, a device, or a label, and a means of identification which enables traders to make their goods or services readily distinguishable from similar goods or services supplied others. A trademark is any word, name, symbol, device, or a combination thereof used by a person, including a business entity on which a person has bona fide intention to use to identify his goods and to distinguish therefrom the goods manufactured by others. A trademark is a sign or three-dimensional sign that individually identifies a good or service and or its source or origin and distinguishes it from other goods and services. It is a device of relationship. It need not provide an absolute objective identification of a particular trader. It needs only distinguish between the trademark good or service from all the other goods or services. Therefore, it could be a brand name or graphic rather than an identifying business name. Uh, for example, you can take brand like Adidas, Puma, Nike, or Coca-Cola, Pepsi. So they have their name, they have their own logo. So that is their brand name. That is their trademark. The logo is the trademark of their company. Okay. So no one can take or no one can take that logo or that name directly. So nowadays, in market we get many duplicate things of those in the name of those product like Adidas. Adidas is edited like Avibas or Nike as Nike. So they can't take the original name, but they can edit it. They can edit the name. Okay. So this is the basically trademark. the logo and the name. Okay. Next is the benefits of the IPR. Getting an IPR will give you an advantages over your competitors. There are some benefits. First one is encouraging innovation and creativity, promoting economic growth, protecting consumer, fostering international cooperation, preserving cultural heritage. So, by protecting the unique ideas and creation, it encourages the creator for more innovation and creativity. People will try to replicate the unique idea on the creation of others for their own commercial gains. Hence, before any third party illegally infringes it, it is very important to secure the IP assets. A person can take IP protection irrespective of the kind and the size of the business. So, after evaluating the business needs and circumstances, appropriate action for IP protection must be taken. It is crucial to note that it is the complete responsibility of the proprietor to protect his intellectual property from infringement by any person or party. So, protecting consumer. Strong IP protects consumers and families. Strong IP helps the consumers to make the best choice about the reliability, safety, and effectiveness of their product purchases. Enforced IP rights ensure the product's authenticity and high quality the consumers expect from the producers. Ease of mind and confidence that consumers demand and markets rely on can be promoted with the help of IP rights. Apart from this, many other advantages also there, like IPRs can enhance your business market value. One of the greatest advantages of protecting intellectual property is that it can generate income for your business in many ways. You could license your IP and lend it to various business in exchange for a fixed income or reasonable royalties. You could also reap benefits from selling your IP products and services for a fixed amount. Selling your IP can raise your profits and even improve your market share. Also, in case you sell your company or enter an acquisition or merger with another registered and protected intellectual property assets can significantly enhance your business value. uh, activities to celebrate this event. So, World Intellectual Property Day is celebrated in a variety of ways. Nowadays, in government offices, in schools or colleges, they host many events, conferences, and seminars to raise awareness of intellectual property and the importance of protecting it. Individuals can also take part in activities to celebrate the day. So, impact of the IPR. So, first one is increased public awareness. Second one is promoting innovation and creativity. Third one is encouraging policy development. Fourth one is promoting international cooperation. Fifth one is supporting economic growth. Promoting international cooperation means the level of productivity and competitiveness in export markets can be accelerated by IP. An IPR holder may use brands and designs to market goods and series abroad, seek franchising agreements with overseas corporation and or export their patented proprietary products. For example, McDonald's and Burger King earlier had franchises only in the US, but now they have franchises worldwide. They enhance their business by taking the advantage of franchising. So importance of the intellectual property rights. First one is raising awareness, encouraging innovation and creativity. Third one is supporting economic growth. Fourth one is promoting international cooperation. Fifth one is preserving cultural heritage. So, World Intellectual Property Day is an important event that serves to raise awareness of intellectual property and the importance of protecting it. It is a reminder to business organizations and individuals of the need to respect the work of others and to take steps to protect their own intellectual property. With this, I would like to conclude my presentation. Thank you.
Thank you, Jyoti ma'am, for giving us a brief overview on Intellectual Property Day. I hope you all benefited from this particular session, and thank you all for joining us. Thank you so much, everyone.
Leave no happen.